So I want to share something with you. This comes off of a U.S. Supreme Court case, um, and it is about the Chevron Doctrine, and it speaks about it, and I want to talk about some of this in regards to the Nicopere Labs Right to Be Smoke-Free Coalition's motion for summary judgment, as well as the FDA slash HHS's cross motion for summary judgment. Certain areas I want to talk to in regards to this case. So this was the October term of 2012, and this is, of course, Supreme Court of the United States, and it was the city of Arlington, Texas, versus a Federal Communications Commission. And so if we go down to page 15, let's move this over just a little bit so I can sort of put over there. All right. All right. This is what it says in relation mainly to our situation. So we're going down to second paragraph, page 15. And this is what it reads. The U.S. reports, which are U.S. Supreme Court reports, are shot through with applications of Chevron to agencies' constructions of the scope of their own jurisdiction. And we have applied a Chevron where concerns about agency self-aggrandizement, meaning, they're very powerful, or at their apogee, I guess, I don't know how to pronounce that, that is at their highest point. In cases where an agency's expansive construction of the extent of its own power would have wrought a fundamental change in the regulatory scheme. And then they cite a case. The threshold question was the appropriate framework for analyzing the FDA's assertion of jurisdiction to regulate tobacco products, a question of vast economic and political magnitude. Because this case involves administrative agency's construction of a statute that it administers, we held Chevron applied. So what they're basically saying is, even though the FDA, that is in our particular case, even though it's and when I read that, and I'm going to get to other areas as well. When I read this, I'm thinking in terms of the deeming authority. Deeming authority gives the Health and Human Services Department Secretary, Tom Price, and then indirectly the FDA Commissioner, Scott Gottlieb, a lot of power. Okay? And when I read this, according to the U.S. Supreme Court, it's okay. It's okay if whatever agency it may be, and in our particular case, it's the FDA, and like it says, even if it's economic and political magnitude, like it says, a question of vast, huge economic and political magnitude, in the sense that you have possibly 99% of the vaping market will be exiting after November 8th, 2018, unless that date is extended. According to the U.S. Supreme Court, it's okay for an agency to have major authority or major power under the Chevron Doctrine. It doesn't matter how expansive. Like it says, the agency's expansive construction of the extent of its own power. Now, the deeming authority gives the power to the FDA / HHS to deem whatever product they want to. So when I read this, I don't know if Judge Amy Berman Jackson, the United States District Court, District of Columbia, is going to cite this particular case in her opinion of the court, or in her memorandum as well, or memorandum opinion of the court. But she may do that. She may say, I'm not saying she will, but we need to be aware of these options here. She may say that the deeming authority gives the power to the FDA/HHS to do pretty much whatever they like to do. That they did not exceed their powers when they grouped vapor products into the Tobacco Control Act. So I was just saying, okay, let's go. It gets a little bit more interesting. Let's go down to page 19. You got to remember this U.S. Supreme Court. Now, the other cases I've been reading about Chevron has mainly come from appellate courts, circuit courts. But this is the U.S. Supreme Court speaking about the Chevron Doctrine. I went through a whole bunch of these cases in regards to tobacco cases in the last few days at the U.S. Supreme Court website. You can pull up all these cases. Everything's available. And I found this one, which was like, uh-oh. But anyway, so let's go down to 19. Okay, here you go. So it states here on page 19 of the opinion of the court, it says the presumably for application of some sort of totality of the circumstances test, which is really, of course, not a test at all, but an invitation to make an ad hoc judgment regarding congressional intent. 13 courts of appeals applying a totality of the circumstances test would render the binding effect of agency rules unpredictable and destroy the whole stabilizing purpose of Chevron. The excessive agency power that the dissent fears would be replaced by chaos. There is no need to wade into these murky waters. It suffices to decide this case that the preconditions to deference under Chevron are satisfied because Congress has unambiguously vested the FCC with general authority to administer the Communications Act through rulemaking and adjudication, and the agency interpretation at issue was promulgated in the exercise of that authority. So what it's basically saying is that the deeming authority appears that it gives a huge amount of power to the FDA, which it does, okay? But according to the U.S. Supreme Court, if they took the Chevron out of the picture, and I'm going to be talking about this dissenting opinion that they're talking about, this one area here. One second here. The dissent, they were talking about the dissent fears, and that is the dissenting opinion. Anyway, if they took the Chevron doctrine out of the picture, then it would create all this chaos amongst all these agencies that are having all these final rules / laws that go into the Code of Federal Registry. So what they're basically saying is the court rather give the agency a huge amount of latitude to pretty much rule or administer their rules pretty much any way they like. That's basically what they're saying. All right. Now, but I mean, they do have to do certain things, don't get me wrong, but still, according to the U.S. Supreme Court, they rather have the agency have the final say as to what's going on with their own rules rather than the courts making up the decisions. And like it says, Congress has unambiguously vested, so there's a two-pronged situation with Chevron. Either the statute that Congress passes is very clear and understanding and can be applied, it's very black and white. And then the step 2 of Chevron is when it's an ambiguous statute, which like what we have. We're under the step 2 in the Chevron Doctrine. But nevertheless, the U.S. Supreme Court would rather the agency decide how to administer their own rule or slash law that is based upon the federal statute, the Tobacco Control Act of 2009, rather than the court coming in to play and telling the FDA how to do their own business. Now, but what's interesting about this case more than anything is the dissenting opinion. Not that it matters in this case because, of course, a dissenting opinion, I mean, all judges on the U.S. Supreme Court, or all courts for that matter that have more than one judge, can have a dissenting opinion and just say, well, these are the reasons why we disagree with the opinion of the court. So if we go down to page 28, he makes good points, this guy. Actually, dissenting opinion on this guy was Chief Justice Roberts, with whom Justice Kennedy and Justice Alito, I can never do his last name, actually joined in on this dissenting opinion. But anyway. So I'm going to read this whole thing. It's a very good point that they made, though. And I tend to agree with the dissenting opinion, but it doesn't matter. And I'm sure you will also, as a vapor especially, agree with the dissenting opinion, but of course, well, it doesn't matter because that's not law, you know. But anyway, one of the principal authors of the Constitution famously wrote that the accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. Although modern administrative agencies fit most comfortably within the executive branch, as a practical matter, they exercise legislative power by promulgating regulations with the force of law. And I've said this repeatedly, that the deeming authority is a way for the FDA, in our particular case, to circumvent Congress. So therefore, I mean, in the FDA, it's no debating. You know, it might be they'll sit around a table and throw ideas around, exchange ideas and things. There's no real debating. Whereas in Congress, you have serious debates because every state of the union has its own constituents, which is, you know, constituents from Maine think and deal with issues much differently, believe it or not, than someone from Arizona or someone from Hawaii, someone from Florida, Oklahoma, or Illinois. So the varied differences are just huge. And this is the reason why that deeming authority is so troubling, at least to me, and I'm sure it is to you, is that it didn't give the Congress the opportunity to debate these issues that were eventually contained in the final version of the FDA final rule. Whereas the FDA, they don't debate it, they talk about it, they exchange ideas, they have a discourse. They have the notice of proposed rulemaking with the public comments, but you could see they pretty much disregarded most of those comments. They only used the comments that serve their own agenda, and the ones they did use, I would say about 99% of them, they disagreed, and they tell you the reason why they disagree with in the FDA final rule. So, like he says, like I said, a very good point he made. They exercise legislative power, and you're supposed to have the separate powers. And the whole point of our government is separate powers, and that is a legislative, executive, and judiciary. And yet, with the Chevron Doctrine, it actually gives the executive branch, or that is the FDA, which is part of the executive branch, legislative powers, which is really, you know, I mean, someone should, just on that point alone, just on that point, should challenge the Chevron Doctrine. But anyway, so so let me continue. Executive power by policing compliance with those regulations, and judicial power by adjudicating enforcement actions and imposing sanctions on those found to have violated the rules. So, I mean, he makes excellent points, these three guys. By policing compliance with those regulations, the FDA has these enforcement powers to police. They could give you warning letters. They could take you to court to seize your products. They can have a point of no sales, so you can't ever sell your product again. You do import bans. They could do all kinds of stuff. And then, like it says, judicial power as well they have by adjudicating enforcement actions and imposing sanctions. Import bans is a sanction. Enforcement actions, they take it to court, civil court, or criminal court. In the FDA final rule, adulterated or misbranded e-liquids, you could wind up in prison. The accumulation of these powers in the same hands is not an occasional isolated exception to the constitutional plan. It is a central feature of modern American government. That's, I mean, that is pretty much, especially since the Chevron Doctrine, that's pretty much the way things are going. These federal agencies are pretty much like a combination, through this Chevron Doctrine, is a combination of Congress, judiciary, as well as their own executive powers, all combined into one, which is really scary. It's not the world that we live in now. They go through notice of proposed rulemaking, all this other stuff, but that's just an exercise they have to do. They have to do this by law. But after they get through that period of time, boom, they just do whatever they like. And goes on to say, the administrative state wields vast power and touches almost every aspect of daily life. The framers could hardly have envisioned today's vast and varied federal bureaucracy and the authority administrative agencies now hold over our economic, social, and political activities. The administrative state, with its reams of regulations, would leave them rubbing their eyes. And the federal bureaucracy continues to grow. In the last 15 years, Congress has launched more than 50 new agencies, and more are on the way. That's pretty much it. So the federal government is extremely bloated. Now, not only is it extremely bloated, but it's given even more power through this Chevron Doctrine to dictate to all Americans how your life will be, without having any debate in Congress, and without the courts saying, hey, wait, hold it here. This is not what Congress, because Congress, of course, is the law-making body. And so you don't have the courts being able to tell these federal agencies, by the way, you're breaking the law that Congress just passed because of this Chevron Doctrine. I mean, I really did this video mainly for this dissenting opinion. Makes a very lot of good points, but unfortunately, no one really, doesn't really matter because it's not law. But it should be challenged with these points that they're making. I got a little reading here to do, but I'm going to read it anyway. Although the Constitution empowers the president to keep federal officers accountable, administrative agencies enjoy in practice a significant degree of independence. As scholars have noted, no president or his executive office staff could, and presumably none would wish to, supervise so broad a swath of regulatory activity. The president may not have the time or willingness to review agency decisions. President Truman colorfully described his power over the administrative state by complaining, "I thought I was the president, but when it comes to these bureaucrats, I can't do a damn thing." President Kennedy once told a constituent, "I agree with you, but I don't know if the government will." That's because they leave all the decision making up to the secretaries or the commissioners or the directors. In our particular case, Director Mitch Zeller of the Center for Tobacco Products, Commissioner of the Food and Drug Administration Scott Gottlieb, and Secretary of the Health and Human Services Department Tom Price. Now, I'm sure they consult with President Donald John Trump every so often, but most of their decisions are made when they make them, without any consultation with the president, like he says. I mean, it's a very good point President Kennedy made. I agree with you, but I don't know if the government will. Shows you so you wonder who is in charge here. And like even President Truman stated, "I thought I was the president, but when it comes to these bureaucrats, I can't do a damn thing." And I'm sure it goes on in every administration. And when they said it, this President Truman and President Kennedy, this was before the Chevron Doctrine. Yeah. So the Chevron Doctrine just makes it even worse. The collection of agencies housed outside the traditional executive departments, including the Federal Communications Commission, is routinely described as the headless fourth branch of government, reflecting not only the scope of their authority, but their practical independence. And basically that, certain federal agencies have these enabling powers, meaning they can enforce their own rules. Apparently the FCC can do that. And guess what? The FDA also has those enabling powers. As for judicial oversight, agencies enjoy a broad power to construe statutory provisions over which they have been given interpretive authority. In Chevron, we established a test for reviewing an agency's construction of the statute which it administers. If Congress has directly spoken to the precise question at issue, we said that is the end of the matter. That is step one of the Chevron Doctrine. A contrary agency interpretation must give way, which goes into the second step of the Chevron Doctrine, which we fall under with the FDA final rule. But if Congress has not expressed a specific intent, a court is bound to defer to any permissible construction of the statute, even if that is not the reading the court would have reached if the question initially had arisen in a judicial proceeding, which goes to what I spoke about earlier, that permissible construction of the statute. That there is so much. In fact, the irony of it all is that this whole permissible construction of the statute is ambiguous in itself, in and of itself. Just the idea of it, because it gives these federal agencies way too much power. When it applies, a Chevron is a powerful weapon in an agency's regulatory arsenal. Congressional delegations to agencies are often ambiguous, expressing a mood rather than a message. By design or default, Congress often fails to speak to the precise question before an agency. In the absence of such an answer, an agency's interpretation has the full force and effect of law, unless it exceeds the bounds of the permissible. And once again, this permissible is open to question. So the permissibility of the statute, so to speak, or the permissibility of the construction of the statute is ambiguous in itself. And that's why they always defer it because the courts don't want really even have nothing to do with it. Basically, they just want to wash their hands of it. Leave us alone. If Congress doesn't, basically what the court is saying is if Congress doesn't have clear intent, we don't want to have anything to do with it. We just leave it. We just defer it to the federal agency. It would be a bit much to describe the result as the very definition of tyranny, but the danger posed by the growing power of the administrative state cannot be dismissed. What the court says in okay, that's where I wanted to go. The framers did divide governmental power in the manner the court describes for the purpose of safeguarding liberty. And yet, the citizen confronting thousands of pages of regulations promulgated by an agency directed by Congress to regulate, say, in the public interest, can perhaps be excused for thinking that it is the agency really doing the legislating. So they're doing the legislation. It's really the FDA, especially with the FDA final rule, is actually legislating through the deeming authority rather than Congress legislating. And with hundreds of federal agencies poking into every nook and cranny of daily life, that citizen might also understandably question whether presidential oversight, a critical part of the constitutional plan, is always an effective safeguard against agency overreaching. Because like Truman says, all these bureaucrats pretty much run the show. I'm the president, but he don't know what's going on with the bureaucrats. And President Kennedy said, I'm the president, but, or something like, what did he say? I don't know. He said, I agree with you, but I don't know if the government will. So apparently, basically, he's separate. And, he wound up being killed, assassinated by his own government. I won't go into all that. But anyway, that's neither here nor there when it comes to all this. But the point is the way it's written within the Constitution is the president has that oversight of these federal agencies. But they're not, the president just leaves it up to federal agencies to decide how to operate. They appoint these secretaries, commissioners, and trust them. It's like a corporation. A corporation has a CEO, right? Or a CFO, a chief financial officer, or a chief executive officer. And then you will have your board of directors, and then you'll have your shareholders. Basically, that's pretty much the gist of the entire company. And then underneath all of that, you have managers and directors and all this other stuff, right? These guys at the top trust those managers to run their business. Period. If one of those managers screw up, then they're out. But that one guy at the top, especially, and the board of directors, they're like, I don't have the time in the day to know exactly what's going on with all of the 500 stores that we have around the world. We trust our managers to manage these stores for us. And it's basically the same thing with this concept here. The president doesn't know exactly what's going on in every single facet of the federal government, but he trusts the secretaries and commissioners to carry out his vision of what he wants. Like President Donald John Trump is all about deregulation. So he says deregulation. How you do it, I don't care, deregulation. Maybe he has some pointers, maybe he's chief of, chief advisor or, chief of staff. Maybe they all intermingle with the secretaries and commissioners. But they're pretty much, the secretaries and commissioners are pretty much left up to do whatever they need to do, excuse me, in order to interpret what that deregulation term means from the president. And the president trusts the secretary, trusts the commissioner that he actually nominated or appointed into that position and was approved by Congress, or I should say approved by the Senate, and leave it at that. He don't know exactly what's going on in the FDA unless he actually sits around, maybe have a weekly update, or I don't even know how they do that. I have no idea. I would think at least a monthly update as to what's going on in the Health and Human Services Department through Tom Price, and then it filters under that. The FDA falls underneath the Health and Human Services Department. But the president just trusts these guys that are under him. Period. Look what happened with Nixon. President Nixon is a perfect example. He was a corrupt son of a you-know-what. And all those that were under him insulated him. In the Watergate scandal, they insulated him, especially Gordon Liddy. Gordon Liddy would have died for this president. That's how corrupt this guy was. And they all insulated. Almost majority of them insulated President Nixon. And they had that trust, that Nixon had the trust of those people that were under him. And when Nixon had his, finger, his hand caught in the cookie jar, so to speak, then those people that he had trusted actually supported him until the very end, when he just gave up, because then he had the Watergate tapes tended to screw him over. But anyway, that's neither here nor there. But it's just the idea that the president trusts those that are under him to carry out this, in our particular case, deregulation. Anyway, it goes on to state, it is against this background that we consider whether the authority of administrative agencies should be augmented even further to include not only a broad power to give definitive answers to questions left to them by Congress, but also the same power to decide when Congress has given them that power. So normally, typically, to do a law, a federal law, you go to Congress. But it's reversed with the Chevron Doctrine, especially even in our case, the deeming authority, which is basically like the Chevron Doctrine in a sense, but it's reversed, and that power is not held in Congress. It's held with whatever federal agency it may be, in our case, the FDA. Before proceeding to, and then they get into this concept of the interpretation of jurisdiction, but that's neither here nor there about in regards to what I'm making a point of. So I made the first paragraph, right? Yeah. Okay. And then let's go to page 32, paragraph 3. And it says this: we do not ignore that command when we afford an agency's statutory interpretation Chevron deference. We respect it. We give binding deference to permissible agency interpretations of statutory ambiguities because Congress has delegated to the agency the authority to interpret those ambiguities with the force of law. And the deeming authority does that. That's very ambiguous, deeming authority. You can deem anything. I mean, the deeming authority itself is ambiguous. But and Nicopure Labs and Right to Be Smoke-Free Coalition somewhat gets into that, but not too much. I wish they delved into that a little deeper. But anyway, the deeming authority is that power that they're talking about here, as far as the force of law. The deeming authority is the force of law that gives the power to the FDA/HHS and indirectly to the CTP, whereas it should have been with Congress to have that power. But what Congress did was they put that little tiny phrase in there, the deeming authority, and just left it up to the federal agency to decide what to do with it. And we see what they did with it. And I mean, this dissenting opinion is spot on. Don't get me wrong. This is spot on dissenting opinion. Unfortunately, it's not law. That's the only problem. Because, you know, the U.S. Supreme Court is the supreme law of the land, right? It's basic knowledge. But anyway. And I could go on a little bit more, but I think you get the gist of it. The point is that Congress makes laws, period. That's what the founders of the Constitution, the framers of the Constitution, that's really what it was all about. And then, of course, you had, in the early 1800s, you had the John Marshall Court. That's where it started at, actually. And the John Marshall Court started to upset that balance a little bit, because they started to say that that's where that whole idea of the supreme law of the land came from, out of the John Marshall Court. He was Chief Justice of the U.S. Supreme Court back in the early 1800s. And it started to offset that balance between Congress, the judiciary, and the executive by giving more power to the court. And the whole point of the framers of the Constitution was to have that balance of powers, separate powers there, but to have a balance there. And then, of course, with the Chevron thing, the Chevron Doctrine, I mean, that just upset that whole balance there, that the federal agency had been given more power than the courts and Congress combined together. And then, in our particular case, you have the deeming authority, which even gives them even more power, more ambiguous power, in fact. That's why it's in a court of law now, or in courts of law, because it's so ambiguous, because they could deem anything they want as a tobacco product. And so that completely offsets that whole balance there. But that's for a court to decide. I really do hope that that Judge Amy Berman Jackson, thinks this really through here, and say, hopefully, what I would like to see in her opinion of the court is that the deeming authority itself is ambiguous itself. And maybe speak about that. She has to cite cases to back up her theory on that, or her opinion on that. But to show that the deeming authority is ambiguous, that would really be an interesting way to take the power away from the FDA. But, that's neither here nor there. I don't really know how she's going to write her opinion. None of the lawyers on the Nicopure or Right to Be Smoke-Free Coalition side knows, and neither does the FDA. When it comes out, it comes out. However it comes out, it comes out. Unfortunately, this U.S. Supreme Court case here, if she cites this particular case, bring it all the way to the top, I mean, she could very well cite this case here. This is, 2013, it's only a little over 4 years ago. She may very well cite this case in her brief. It would not surprise me that she cites this case in her brief, if she decides to invoke that Chevron Doctrine. So I want to just give you some thoughts, some more options, some more thinking, and something to think about. And just wait for her decision. Hopefully the PMTA modified risk claims, at least in part, are granted to us. Of course, it goes up on appeal. And this could be challenged in the deeming authority itself. It can be challenged in the United States Supreme Court. I would like to see that actually go that route, to say that the deeming authority itself is ambiguous, and see how the U.S. Supreme Court rules on that. That's the way I would take it if I was a lawyer, but of course I'm not a lawyer. But if I was a lawyer, that's the way I would frame my argument to the U.S. Supreme Court, is that the deeming authority itself is ambiguous. So anyway, on that point, I'll let you guys go. Bye.